be proactive. Get these policies in place. You don't want some tinkering and inventing something and saying, okay, I invented this, I'm leaving, and it's competitive. Now you may have a claim against that employee, but you have a much stronger claim if you have a written agreement or at least a policy that they violated. So be proactive, put these things in place now before they can hurt you.
This is the Rebel HR Podcast, the podcast where we talk to HR innovators about all things people leadership. If you're looking for places to find about new ways to think about the world of work, this is the podcast for you. Please subscribe from your favorite podcast listening platform today and leave us a review. Rebel on, HR Rebels. All right, Rebel HR listeners, welcome to this week's episode. Really excited for the conversation. This is going to be fun. A little bit of a different slant on employee experience and retention. With us today, we have a wonderful guest, Josh Hawks-Lads. He is a co-chair of the Labor, Employment Law, and Employee Benefits Department at the law firm Pullman & Comley. Practices in Connecticut, New York, Massachusetts, and Rhode Island, as serves as outside general counsel to numerous companies nationwide. Josh, thank you so much for joining us today.
Very happy to be here. Come on.
Well, I am really happy to have it. You are a super busy guy, and the fact that we have an opportunity to talk is just really awesome. So, I want to ask you the question that I'm always fascinated to learn about anybody who is in employment law. Why did you enter the world of employment law?
Well, so this might be sort of a mundane answer, but I will tell you that I fell in love with it intellectually in law school. And one of my professors taught us about the interaction between management and labor. And there was a very famous quote by the Canadian Prime Minister, W.L. Mackenzie, who talked about labor can do nothing without management, and management can do nothing without labor, and neither can do it without the genius of leadership. And that's a paraphrase from him. Everyone can Google that and see. And I love that idea that labor and management must find a way to work together in our capitalistic system in order for companies to succeed. And I fell in love with employment law and labor, and I focused on that right in law school. And then for my last 30 years of practicing, I've been handling all types of HR and labor and employment matters, and including the topics we're going to talk about today.
Well, I really appreciate that. And you know, the more that I've been in the world of human resources, you know, the more time you spend in it, the more exposure you get to kind of the legal side of the business, right? And it's just kind of a natural overlap. And what I found is, you know, lawyers are not, you know, there's not just one type of lawyer, right? Like you've got their specific types of lawyers, and I just have a soft spot in my heart for the employment law professionals. So kudos to you.
Thank you. Good to hear. Well, you know what? It's because we have to work with folks like you every day, and you know how tough it is on both, on our side, on the legal side, and on the HR side. It's a tough world out there.
Well, and so often it's like, you know, the conversations start with, we need help. What do we do?
Correct. Yeah.
So with that in mind, one of the things right now that we're all facing, you know, is the labor market, you know, whether it's trying to attract talent or retain talent. And a lot of times we spend, you know, a significant amount of our time thinking about, you know, culture building and being a great place to work, impacting the employee experience, and all those things are really critical. But there's a whole nother aspect to the employer-employee relationship, and that's kind of the legal side of it, right? And so today what we're going to talk about is employee retention and attraction from the aspect of the legal employment relationship. So Josh, I think, you know, the first question there is, as you look at what's happening in the talent market, what are some of the kind of the key legal provisions that we need to be thinking of as we're hiring employees and trying to retain them in our organizations?
Okay. So there's really two issues. There's a lot more than two, but two issues I'd focus on in this crazy market that we're in, this crazy labor market where everybody's fighting over the top talent, right? And human capital is so precious. There's really two things, right? Money What are you offering? And culture, you just mentioned culture and DEI and all those things. But money is a focus, and of course, happiness and all of that. But then also, what type of golden, either handcuffs or what type of tools can you utilize right from the get-go, to keep your talent? So let's just start on this issue of attracting and retaining talent. Of course, you can use bonus programs, you can use retention bonuses, you can use sign-on bonuses, you can use more money. I mean, that's what's driving the labor market and wages going up. But once you have that talent, how do you keep the talent? And again, you've got, as an HR professional, you know all the tools that you can use to try to keep people happy, both monetarily and culturally. But when do you use an agreement, a restrictive covenant agreement, to try to lock someone in to a position or prevent them from going to work for a competitor, or stealing your trade secrets or stealing your customers or employees? So there's a very, very high focus right now on restrictive covenant agreements. And by the way, the focus on both sides of the fence. Employers are focused on it. They want more and more restrictive covenants to stop employees from damaging their legitimate business interests. But the government's watching. And you probably know in 2021, the federal government tried to pass a national bill restricting non-competes. That failed. But more and more states are passing legislation restricting non-competes on many, many levels. So there's this real tug of war going on between employers trying to use restrictive covenants. And by that, I mean non-compete agreements, non-solicitation agreements, and the like. So employers using those tools to prevent employees from what the case law refers to as using the weapons that's placed in the employee's hands against the employer in a competitive way. And on the other hand, the government trying to regulate that. And many, many states have been putting in place restrictive regulations preventing non-compete, or California, for example, completely eliminated non-competes years ago. But areas like Massachusetts have greatly restricted non-competes. Rhode Island, Maine, and other states are limiting them. Illinois, Colorado, Nevada are limiting them in many respects, especially for hourly workers, which to me is an interesting issue, because I've always told my clients, you can't justifiably use a non-compete to prevent some low-level worker from going to work for a competitor. You have to have a legitimate reason, what the courts call a legitimate business interest, to enforce a non-compete. So in this market, there is a real tug of war going on between management and employees and those governments that do not want to see anti-competitive, antitrust, anti-capitalistic behavior. And on that last political notion, remember, we're a capitalistic society, which basically it means that there should be a free flow exchange of goods, personnel, ideas, everything. So non-competes are they limit that, right? So there's a public policy against non-competes unless the employer who's trying to enforce it can establish there's a legitimate reason for it, and the non-compete is reasonable in its scope, geographic, time, and what it covers. So right now we're in a unique area because of the battle over good employees, the employees moving, the whole quiet quitting people. Employees are leaving for dollars, culture, et cetera. And so this restrictive covenant agreements are not becoming, but they are really at the forefront right now. At least that's what I'm seeing. And my practice is national, as you mentioned, and a lot of my clients are enforcing them. And on the other hand, a lot of my clients that are executives are trying to get out of them. So it's a tug of war.
Yeah, tug of war, I think, is a good image, and I think you there's a lot of really important points there, and I think one of the maybe things that I think is really interesting as far as where I sit and where most of the HR practitioners sit is, a lot of times we like to think, we don't need this. We want to trust people, right? But like you said, there's a tug of war. I think about it, it's like a math equation, right? It has to balance out. And yes, you need to do all the things that are really, really important to get somebody to join the company. Yes, you need to have a culture of trust. You need to do the right things. But there also does need to be some oversight, some protection for the business. And that's where I think a lot of times HR is kind of in the middle of the tug of war between the employee, the candidate, and a lot of times like the legal counsel or CFO or whoever's in charge of risk management, where it's like, well, let's we want a 5-year non-compete, non-solicitation, and if they violate it, we'll make them pay us, all these, and it's like, well, wait a minute, we've got to have some guardrails here, because I do think it's important that HR as a risk manager needs to also be mindful of what's appropriate for all of the parties involved. So to one of the maybe important points and points that I think really often gets overlooked, when we talk about the actual parties that we include in a restrictive covenant agreement, what kind of jobs or functions or level of positions should we be considering this as a lever for retention and protection?
A really good question, because, and actually before that, to your point about HR being in the middle, you are 100% in the middle, and you're right. You're going to have your, I don't know your organization, but your head of sales who's going to want a 5-year non-compete and preventing the employee from going anywhere at any time, and doesn't want to pay for it. And then you have your legal counsel or you saying, well, wait a minute, you can't do that. The laws won't allow it. So I feel for you. I feel your pain. And then I come in as outside counsel and I say, and you did what? And you did what kind of an agreement? And one of the things I look at is the question that you just posed is, who are you as an employer subjecting to a non-compete? And let's keep in mind that I want to differentiate for the audience. I want to differentiate between a non-competition agreement, which prevents an employee from going to work for either a certain entity or in a certain locale or in a certain industry, or sometimes all three, versus a non-solicitation covenant, which says you won't go after our employees or customers. The non-solicitation courts look at much more, I'll say liberally, but they don't scrutinize quite so hard as a non-compete, which basically could take away someone's livelihood for a period of time. So if you people out there are using non-competes to force every single employee from the maintenance worker and the administrative assistant all the way up to the CEO to prevent them from going to work for a competitor, a court will look at that extremely askance and say, wait a minute, the purpose of the non-compete has to be to protect a legitimate business interest. And you can't stop a secretary to go do secretarial work at a competitor. You can subject her to a confidentiality agreement, no problem, but you can't prevent her from going to work. So if your company is using a non-compete just to try to prevent employees from leaving and going to work for a competitor, that document, it will not only not work, but the fact that you, this fictitious employer, use it for all employees waters down the effectiveness when you really need it for that key salesperson who has the customer relationships or the contacts in the industry or whatever. And when you're litigating a case, which I do all the time, and the plaintiff's lawyer points out that, wait a minute, you use this for everybody. The real reason that you use this non-compete is just to stop people from going to work. And that's not a legitimate reason. So employers must be very careful that they limit the non-compete to those people who are armed with the weapons that can hurt the employer. And what are those? Those are obviously trade secrets are one, but you will have confidentiality agreement, business plans, the unique business ideas and future plans for a corporation, customer relationships, of course, because companies entrust people with key relationships, and they invest in those people with those relationships, and that's a legitimate thing to protect, and the like. So there has to be a bona fide, important business interest to protect, and therefore the non-compete should only be given to those employees who can actually hurt you. And then, of course, they have to be reasonable, as I mentioned, geographically and within time. You can't just, as we joked about, say, okay, 5 years, everyone's 5 years. And I'll just talk about that one issue for a minute. What I tell my clients is you want the non-compete to be the shortest period of time that you need to maintain that business relationship that you're afraid you're going to lose. And I'll have clients come in the door and say, we want a 2-year non-compete. And I'll say, why? Why do you want a 2-year non-compete? I said, because we want it. I said, let me ask you something. If Joe Smith leaves your plant and goes to work for a competitor, how much time do you need to go out, call all of those customers and make sure that they're staying with you? Oh, we're going to do it right away. We're going to do that right away. Of course, we're going to do that. I was like, okay, so then what do you need? 6 months? A year? Yeah, probably we could get it done in a year. So then my question is, well, why do you need any more than that then? If you can get those relationships in line, staying with you, making sure you're taking them on those golf outings and doing all those junkets, and they're staying with you, well, then why in the world do you need 2 years? Because 2 years is tough. A lot of courts don't like long non-compete. So the legitimacy of the time period is also a factor. And I think I talked for a while. Hopefully I answered that question.
Well, it's so much good content. And I mean, I'll be honest with you. When many of us get in HR, there's very few of us have any sort of legal background, right? I mean, there's a couple, all-stars out there that took business law, or, I randomly had an elective in, business school. I had to take a business law class, and I think the only thing I remember is that tort is a thing, right? It's like
it's a sweet thing, right?
Yeah, exactly. It's so, I think this content is really, really critical and important, because what happens so often in our careers is, as they progress, we start to take on like a pseudo, legal representative role, and people will call us and ask us these types of questions. And if we aren't thoughtful, and especially as it relates to employment contracts and employee agreements, we could lead our organization down the wrong path. I think probably the most important thing that I want to call out here is, if you have these questions, contact an attorney that's licensed to operate in your state. That's probably the best answer that any HR professional that's unsure can give when they're having a legal question. And this isn't
Absolutely.
legal advice, by the way. I'm not a lawyer. I'll keep our, the FCC happy there.
No, but that's smart. That's smart common sense advice. That's what that is.
Yeah. There you go. So, but I think it's really important. I mean, I've had this conversation. I can't even tell you how many times where somebody's like, well, we need to give this person a non-compete because they are, in the manufacturing sector, they're working on a machine that's new, or they're building something. This is a new innovation, and, we need to make sure that they don't tell anybody. And, the question is, well, does the CNC operator that's cutting out this new style of gear really have any risk to the business, and the longevity of this product? Well, no, they're doing a really small component of a much larger innovation, and the actual risk there is pretty low. And if we were to prevent them from going and working in a competitor, in my region, we just cut out about 60% of the available jobs for them to go work, right? So it's like, there's no way in God's green earth is that ever going to work, right? But one of the questions I did have as you were talking, and just, as we talk about kind of the changes in the legal landscape, and the changes in, just in people's approach towards the employer-employee relationship, is we're seeing so many more people with side hustles, or with, like, maybe they work in a certain area in engineering during their W-2 job, but they're, maybe they're consulting a little bit on the side, or maybe they're in their garage tinkering and, and making up, innovations and things like that. So as we think about the restricted covenants and employee agreements and non-competes and all these types of things, how does kind of this new wave of folks who are entrepreneurial and looking to have side hustles, how do we think about that as we think about the employee-employer relationship?
So that's a really good question on many levels. And I don't want to be too legal in my response, but this is, again, the overlap between legal and HR. When you're calling your outside consultant to review your policies and procedures and all that, first thing I do is I say, okay, well, what's your inventions agreement? What's your policy on works made for hire? Right. And I'll talk about what that means in a second for any of the folks in the audience that don't know. And more importantly, what do your policies say about what an employee can and cannot do after work or on the weekends or on vacations, that may pose a conflict of interest? So, I'm sure many in your audience have employee handbooks, personnel policies, all kinds of things. Part of the problem is solved by having in place rules that employees must follow. Whether it is that you cannot engage in any work that is competitive with ours without disclosing it to us, getting our permission. You can't do anything for a fee that's competitive, especially when you talk about the tinkerer. But so that should be covered by some sort of written agreement or written policy. That's the only way. If you don't say anything, if it's not written down, well, then the employee's going to do whatever they want to do, as I'm sure you and the rest of your audience knows. But let's talk about inventions for a minute, because we've had some amazing entrepreneurs, whether it's Bill Gates or Steve Jobs or whoever, that built things out of their garage. Like Amazon was built out of a garage, right? And selling books out of a garage. Now, I don't think he was employed elsewhere at the time, Bezos, but if he was, that employer could say, well, wait a minute, you owed us that invention, that work. You did that for us, not for yourself. And guess what? There'd be a huge battle there. But if there was an agreement in place regarding discoveries, inventions, and works made for hire, which maybe your company, maybe a lot of companies have this in place, well, then there wouldn't be an issue. And that employee, whatever's being invented, has to disclose it and has to provide for the fact that the employer owns it if it's made during that time period, unless it's excluded. So, and this may be legalese. This is why everyone hates lawyers, because I look at it black and white, and I'm like, well, put something in place to protect. You talked about protecting the employer a few minutes ago. Well, you've got to protect the employer with these agreements. These agreements are important. And if you're not taking it upon yourself to protect your company through these agreements, whether they are conflict of interest policies and invention policies, works made for hire, non-solicitation, confidentiality, well, then sorry, but shame on you, because you're going to get that one bad employee who's going to do something that you'll be like, what? He or she can do that? So be proactive. Get these policies in place. You don't want some tinkerer tinkering and inventing something and saying, okay, I invented this, I'm leaving, and it's competitive. Now you may have a claim against that employee, but you have a much stronger claim through tort law or through statutory law, but you've got a much stronger claim if you have a written agreement or at least a policy that they violated. So be proactive, put these things in place now before they can hurt you. That's my advice.
Yeah, I mean, so it's for me, it's really just it's an internal struggle, because I'm one of these guys that, like, I don't love policies, certainly don't love 100-page handbooks that you just like throw at people and say, here, read this and sign this acknowledgement, check the box on orientation day one, but I think if this is a concern for your business, certainly if it's a concern for your executive team, the expectation is that you have some of this in place as an HR professional, right? I mean, I think that it's what I would call like you're blocking and tackling, right? Like you need to make sure that you've got the basics documented. And as I think about the level of importance of policies, like I'm okay with policies when you absolutely need a policy. But I think if you're listening to this and you're in a situation where you've got a high risk of, IP theft or or you've got people doing side hustles that could be directly competitive to your core business, it's probably something you need to think about. And potentially it's something that is that somebody else is concerned about as well. So, talk to a business partner within your organization and see if there's something you need to do. But good advice, yeah, and good reminder. I'm just making a note right now to go see what our inventions agreements look like. I don't remember; it's been a few years, but
I'm not charging.
Okay, thanks. I appreciate that. Yeah, I forgot to mention, this isn't actually a real podcast. I just don't want to pay, the hourly fee. It's way too expensive. No, I'm kidding.
you and everybody else out there.
No, it's really great advice, and I think it's really well stated. I do want to ask a question because I know you get into litigation, collective bargaining agreements. You've probably seen it all and more than you wanted to see in some cases. So I'm curious, just over the last few years, if you're seeing any sort of trends in your world, because of kind of the changes that we've seen in the workplace and the dynamics around the talent market. Any kind of macro changes that you're seeing out there?
We'll be back after a quick break.
And so used to having everything in front of them right away that we forget that innovation just takes time. I myself get frustrated too. Why? And this as being one of my best friends is, hey, I talk to you all the time. Hey man, I'm frustrated in the fact that I can't seem to just get there in the next day. But that's just not how these things work, right? Innovation needs to be planned out. It needs to be very methodical. And then when it finally hits, that's when it seems like to everyone else that it sort of just came out of nowhere. But to you, the amount of dedication that it took over that time.
And this is not related to the topic we've been talking about, really completely separate, but I see a major trend in the discrimination and harassment arena that, and I think it started with Me Too, where things really blew up after Me Too, and rightfully so in many respects, where you had, every other celebrity and politician being accused of assault and all that. And then many, many states changed their harassment laws to require training, sexual harassment training and other discrimination training and posters and all of that. And I think what arose out of that, the publicity around it, was more litigation. Some of it valid, some of it with people using the discrimination laws as a sword instead of a shield and really going after employers. We're seeing it, a lot more litigation in that arena. Also, the whole push towards DEI and wokeness and political correctness has contributed to our claims and allegations that employers are not being politically correct and not culturally sensitive. And so we're seeing I would tell you this, we're doing a lot more training than we've ever done. Every employer now wants more and more training. But I'm also seeing, I think on the negative side of things, more and more litigation. Now, there was always been litigation since the 60s and since these laws came into place at the federal level and state level. But I'm seeing the harassment and discrimination claims more frequently. And like I said, I'm not sure whether or not it's because people just are now so much more familiar with their rights, which is possible. Because I don't think, and by the way, to all the employers out there, if your people are still sexually harassing employees in this day and age, there's something wrong. Because everybody should know after Me Too that sexual harassment is verboten. So make sure your folks are trained, but it's out there. So I think that's a major trend. And I'm not sure exactly whether all of these factors I named are contributing to it, or it's also the fact that post-COVID people are more sensitive to so much. If you look on TikTok or Instagram, there are just so many instances of insensitivity out there and people being aggressive, and some of that obviously spills over into the workplace.
Absolutely. I've certainly seen that internally. I think, I think Me Too was a turning point, and I think in many ways a really good turning point to shine some light on some of these things that were occurring that just weren't okay. But I do also think it's another good reminder that as we think about the employer-employee relationship, the expectations on both sides are continuing to increase, and that that's something where we need to be balanced in how we approach it. I'm glad to hear there's more training happening, because I think for my money, that's one of the best investments you can do, is to make sure people are clearly understand the expectations and deal with it before it gets to a courtroom, right?
Agreed.
I'm sure you probably agree. Although I bet you do enjoy litigating here and there, right?
I do. But what you say about litigation is you do it and you're over with. You don't form client relationships over litigation. Like, oh, that's the litigator. Most of the lawyers in my field want to make relationships with their clients, and litigation is so stressful and so expensive that it often hurts more relationships than it builds. But yeah,
I've seen those bills.
Yeah. Exactly.
All right. Well, we are just pushing up to the end of our time together, and I want to get your responses to the Rebel HR Flash Round. So, are you ready?
I'm ready.
All right. We'll go through the closing arguments here. All right. Question number 1: where does HR need to rebel?
So I don't want to be cliche with my response, but employers need to stop being held hostage by problem employees. Employers need to do their fact find, make a decision, make the right decision, and act. So many times I get involved in matters where clients vacillate, and they've got a bad employee. When you've got a toxic employee, don't be held hostage. Act and call your lawyer for advice.
Absolutely.
And your HR physician.
Yeah. I've seen it so many times, and a lot of times we think if we, ignore it, it'll go away, or the person might eventually just get fed up and quit. But what happens, the trickle down effect to the rest of the team, when that negativity can be extremely harmful to your culture if you don't address it, or your business interests as well. Right. Question number 2: who should we be listening to?
So that's a tough question, especially because I'm not a huge listener. I'm more of a reader. But there are certain things that I go to. For example, anytime the Arbinger Institute has a podcast or has something on YouTube regarding an outward mindset, I listen to them. There's a good, again, I don't want to talk too much about any of your competitors out there, but Jonathan Westover has a very good human capital innovations podcast that is great for HR folks. And then I read voraciously, and I love George F. Will's opinions, and I'm not even I'm not a conservative, but he and Peggy Noonan, Wall Street Journal, their opinions on our culture, our politics, and where we're going are very useful as well.
Absolutely. Yeah, we don't have any non-competes in the podcast world, at least nothing that I'm aware of. So I think it's all good. And anybody that's driving innovation in the HR space, we're brothers in arms as far as I'm concerned. So, last question: how can our listeners connect with you?
Well, they can find me on LinkedIn, of course, and my firm's webpage, which is Pullcom, PULLCOM.com. They can check me out there and email me. Hopefully, it doesn't hit my spam account. But those are two of the best ways. And my firm also blogs, and we have a Working Together blog that talks about a lot of these issues, so folks can read that as well.
Awesome. And we will have that information in the show notes. Josh, it's just been absolutely wonderful getting to connect with you and learn a little bit more about something that we don't discuss frequently on this show, but something that I think is really critically important. So thanks so much for joining us.
Been my pleasure. Really appreciate it and enjoyed it, man.
Thanks, Josh. Take care.
Take care.
All right. That does it for the Rebel HR podcast. Big thank you to our guests. Follow us on Facebook at Rebel HR Podcast, Twitter at Rebel HR Guy, or see our website at rebelhumanresources.com. The views and opinions expressed by Rebel HR Podcast are those of the authors and do not necessarily reflect the official policy or position of any of the organizations that we represent. No animals were harmed during the filming of this podcast.
Baby.